We'll turn it over to Nate and Joel.
What do you have to say?
Do you want to start out or do you want me
Why are we here?
to? Yeah, good question. Good question. So, can you guys hear me without a mic up here right now? Good. So, good morning, everybody, first of all. This speedy trial concept is one that I learned about 2 years ago or so. It's something that frankly scares me a little bit because conceptually, what you can do is take a case that we would typically take 2 weeks to try and try it literally in a day and a half. So we're talking about shortening witnesses down, expert witnesses to 20 minutes as opposed to 3 hours or a half a day or whatever it is. We're talking about shrinking the number of witnesses, talking about just overall shortening the trial and really focusing on what our jury needs to find for us and for our clients. I have used some of these techniques, but I'll tell you that I have not had the guts yet to take a complex case that we typically would take 2 weeks to try and shrink it down into a day. This guy has, and I think what Joel will tell you is part of this is, necessity is the mother of invention. So he's gonna tell us some stories about a few cases that he had over the last year that were sort of dropped on his plate late in the game. And so Joel said, hey, what a great opportunity for me to use this technique. And he had great success with those cases. And so I'm gonna hand it over and let Joel kind of talk about his experiences, what he's done, and how this worked for him. So we can all learn from those. Thanks, Joel.
Great. Thanks, Nate. So Nate is right. Last year, one of our associates had an opportunity to take a position with the Attorney General's office that he was very excited about. And we were very excited for him, except on a selfish level, it created a lot more work for those left behind. And another fortunate thing is that we're 5 attorneys. We have at any given time probably only about 40 active files. There's always some at the beginning and at the end of their phase of life, but 40 active files, 5 attorneys. So typically we'd have 2 attorneys on every file plus a paralegal. So when Andrew left, he had some trials coming up, and in short order, in addition to all of his other files and my own files and running the firm and things like that, it was an opportunity for me to either leave and go to Tijuana and not come back, or try to figure out how to get through this. And so I had 3 trials. One was in, actually there were more, but we were able to resolve a couple of them. One was in April, the next was in June, and the next was in August. Plus I had one of my own trials in between April and June. So it was kind of a busy time. And tell you a little bit about the cases. That my whole goal of the speedy trial is not to bore anybody. So I'll try to be consistent with that concept in this presentation. But the first trial, they were all nursing home cases. The 3 cases were nursing home cases. And the first case involved a man named Ronald Lund. They were like all the other plaintiffs in the other cases. He was an incompetent person legally, both physically, well, not physically, but mentally. He couldn't look out for himself. And he went out the window of a 3rd-story memory care unit at a nursing home in St. Louis Park. The case was pretty heavily defended. The insurance carrier was on it seemed to me, kind of a scorched earth approach to defending cases and not settling them. And all 3 of these cases ended up being cases involving that liability carrier. Different counsel in each case, but the same liability carrier. 2 of the cases had the same nursing home. The third case was run by the same organization, but at one of their other nursing homes. So Mr. Lund went out the window, amazingly survived. He's a pretty tough guy. They defended it. They thought they were going to win on liability. And so we gave them an opportunity to resolve the case for about a third of what the jury ended up coming back with. And we had, by the way, right before that trial was my family's long scheduled spring break trip, which Joel was not allowed not to go on. So I had to figure all this out even before I went on vacation with my family. I've heard of lawyers doing that, like Mark Lanier in Texas. He goes, to south of France for a week to read books on the beach before he starts some major multi-billion-dollar case. I admire that. I've just never been able to figure out how to be so prepared that you could do that. So, but I tried. Prepared or not, I went on vacation. I had a wonderful group of people trying to put these together. But what I want to share with you today, after I quickly go through these three cases, really visualize what I was trying to teach the people trying to help me, and to try to train myself in terms of, instead of getting overwhelmed by everything, what's the point? And I think my staff and those helping me got so tired of me saying, what's the point? But it was actually very good discipline, and you'll see that in some of the visuals that I want to share with you. So anyway, the Lund case we had, it's a nursing home case, so we have to have expert witnesses, at least a standard of care and a medical expert, so 2 experts. And we did, we started on a Tuesday, and nope, we did not. We started on a Monday. Nope, we did not. Keeping on your toes. We started on a Wednesday. We started a trial in the middle of the week. And on that first day, we had our motions. Even if you have a pretrial conference with your motions in limine, it seems like lawyers are never done talking about things. So we still had some motions in limine at the beginning. Typical, as you all know. Selected our jury. We did our respective opening statements. And then I got my first witness in that afternoon. The next day, we ran into a glitch. I would have gotten more witnesses in on the first day, but the courthouse got shut down. I think there were some, maybe some legal things going on with the George Floyd cases or something, but they shut down the courthouse. I can't say why, but I felt like there must have been some sort of threat or scare. So off we go at 3 o'clock, and we're all set to start the next morning, the second day of trial at 9 o'clock, and one of the jurors doesn't show up. So he misunderstood what the judge had said the day before in the haste of getting out of the courthouse. Very apologetic. He shows up about an hour and a half late. So we start at really the morning break. We have 3 experts, 2 late witnesses. We got our exhibits in, and we rested on that first day of the plaintiff, really the first full day of the plaintiff presenting their case. Then the defense on Friday got their witnesses in very short. They got their exhibits and they rested. And then the judge, instead of cramming this on the jury on a Friday afternoon, set Monday morning for closing arguments, which we did. And then the jury deliberated for a couple of hours and came back with a verdict that was almost $1.4 million. The second case was the Jackson case. Nina Jackson, she was at a nursing home in St. Paul, physically and mentally incompetent. She developed a very serious pressure wound, bed sores is one word for it. Venous ulcers is something doctors call it. But pressure injury, pressure sore, bed sore is very bad. And again, they defended the case pretty seriously. We had made Rule 68 offers in this case and in the prior case. And in this case, the insurance coverage was $1 million. We did a Rule 68 offer for $1 million. The jury came back with a verdict that was about almost $2.1 million. In that case, we started on Tuesday, the day after Memorial Day, and we had motions, jury selection, opening statements. We got our first witness in. On Wednesday, we got our 2 experts, and I called 2, I like calling, if I can have enough confidence, I'll call 1 or 2 witnesses from the other side of the case, in our case. I had called 2 of their witnesses, and then the guardian for my client. We didn't rest because I just wanted to make sure I was good on my exhibits, so then we rested the next morning. And then the defense called a couple of witnesses. On Friday, they called a couple more witnesses, and then they rested. Once again, we had a weekend break between the parties concluding their cases and the jury hearing the closing arguments. They deliberated for a couple of hours, and we got a nice verdict in that one as well. And so at this point, I'm liking the speed trial concept. I'm not a master of the speed trial. It says mastering the techniques. I'll tell you a little bit about how I learned about them and started them and so forth. But this was game time to actually using them. So then the third trial was Raymond Biggis. This is a wrongful death case, and we started on a Monday with motions, selecting the jury. And then for some reason there was a delay. We started on Tuesday with our openings. I got my 2 experts, 3 lay witnesses, including some of their witnesses, got our exhibits in, and we rested at 3 p.m. The next day they had a couple of witnesses. My cross-examination of each of those witnesses was maybe 5 to 10 minutes. One of the witnesses I didn't even cross-examine at all. I am lazy by nature, but it wasn't for that reason I didn't cross-examine their witness. I just felt that at that point I had a pretty good feeling about how it was going and the jury's reaction. And then Thursday was closing arguments. They deliberated for an hour, and we got a $1 million verdict on a case that we had offered to resolve it for about a third of that, and a 0 offer going into it. So those are the 3 cases that really forced me to do something more seriously about these techniques or strategies that I had been dabbling in for a couple of years. I had met Joe Freed in a couple of professional groups that we belong to. I really like Joe. Joe is the speaker that Nate introduced, who, if you really wanted to learn a lot about the speed trial techniques, Joe is constantly, improving. If it worked last time, he'll try to make it better next time. He'll be honest about when it doesn't work. So I really admired Joe. He was somebody that I was inspired by, and he seemed to walk the talk, and he was getting nice results with this. So the idea, this is the part where I want to just share with you a little bit about visualizing how I share with my staff, the people that are trying to help me be smarter. And these cases, we do plaintiff's work. I really can't, I'm not here to tell anybody what to do, but I certainly try to anticipate what the defense is going to do, what their strategies are. The best defense lawyers I've come into are the ones that have a really strong talent for, I build a house of cards and they know exactly which card to pull out to make the whole thing collapse, or the plug in the sink. I can fill the sink up with water, but they have this ability to pull the plug, or the Achilles heel. So I try to look at our cases the same way. What is the defense going to do? And if I'm on the defense side, I imagine I'd be, of course, what's the plaintiff going to do? But either way, at least from my perspective, we've been working on the case longer than the opposing counsel has been, because we've gotten it from day one. Usually we're worked it up, and then at some point it falls in the lap of the defense attorney. But there's facts, there's arguments, there's images, impressions, there's the cost of handling it, the business of a case, but you've got all the issues that go into the case, all the records you have to get, and understanding them and what do they mean, and rules. And among other things. And so all of these things are the case. And if you have 40 cases or 100 cases, you've got 100 or you have 40 of all of this for each case. So when it was crunch time for me, I really didn't have the opportunity to know everything about the case. And so I thought, okay, you got some really smart people, you guys are working hard, I'm trying to work hard, I'm trying to be smart. Teach me here's what I'd like to know, because I can imagine what it's like to be in front of the jury and what I'd like to tell them. And this is kind of what I get. And I think we think of, with all the things that we're juggling, the idea is to get from A, which is where you are, to B, where you want to be, whatever that is. And this is that maybe most of you are better at just getting from point A to point B than I am. But this is what it is. And this is if you're lucky, because this diagram shows that we actually got to point B. It just was a meandering opportunity to do so. There's a really good chance that you're not even going to get to point B. And where are you going to end up? Okay, that's great, Joel. Thanks for the drawing and all that. We get it. So again, all this stuff that we have to keep track of in a case, what's the point? And what's the point is the question I asked on everything. I mean, for our motions in limine, the for hearer process. As a plaintiff in state court, I have the advantage of, some would argue it's not an advantage, but as far as finding out information, the judge will ask questions first, as you know, then my opposing counsel will ask questions of the jury panel, and then I get a chance really to have had some time to think about what I want to do. So we've got all, I don't want to call it clutter, but we have all the stuff that goes on in the case. And ultimately, you can't just dump that big sack of stuff in front of the jury. And I think a lot of us, or at least a lot of trial lawyers, kind of end up doing that. It's just not being sharp in exactly what you want to say or show. And I think because we fear or we're afraid that if I really concentrate this thing, I'm going to miss something, or there's something that some juror is going to be thinking of, that if I don't address that, and by the time you add all those things up, you're talking about a whole bunch of stuff that really isn't the core of your case. So,
Joel, can I ask a question on this? So this is what I was saying at the beginning. Part of why I've been a little hesitant to do this is, if you've ever run through focus groups or been lucky enough to have a jury talk to you after a trial, sometimes, I shouldn't say sometimes, more often than not, I've been surprised what jurors latch onto. And I will hear them say things and I just kind of think, shit, I didn't think that was that important, which makes me scared to sort of whittle my case down to what I think is important. So could you talk just a little bit about the process that you go through to kind of hone in on what's really important? And maybe that's in another slide and I'm getting ahead of you.
So yeah, I mean, that's always, case dependent.
Yeah.
I'm only one of the 3 cases I had a chance to do a focus group on, and it was the first one. And I like to play the defense lawyer in the focus group and then have one of the associates present the plaintiff's case. And in part because it forces me to be in those shoes to try to figure out what I think my opponent is going to do in the case. But focus group is the answer. Focus group is a pretty big, broad term. I mean, you could do a full-blown professional focus group. I've done focus groups before where we went to a nearby church. It said, it's not scientifically accurate, but it forces you to put your case together and present it to people and hear what people have to say. But give us 8 or 10 people in a place to present this, and we'll make a donation to your church. That's about as simple as we've done it. MAJ, there's professional groups that offer focus group opportunities to their members. So I'm not set up to have somebody in my office arrange our own group of people. So, but there's a wide variety of things. We did one focus group where we hired a lawyer that we admire, who at this point in his career was really good at doing focus groups, which was also a nice opportunity to figure out which cases he might want to get involved in as counsel. But we did 4 focus groups with him in 2 days. And we learned from the first one, we tweaked it, tested something else in the second one, and then we did 2 more the next day. That's about as elaborate as we've gotten. We've worked with Diane Wiley and her group to do focus groups, like I'm sure many of you have as well. But not every, I mean, I can't justify that expense on every case. And some cases are an awful lot like the last one they had, where you don't necessarily need to test things. But it's a good one to test. I mean, you're sort of forced to economize anyway for a focus group because you only have so much time. And so the one focus group we did was very helpful. One of our associates at the firm knew a lot about this particular facility just from life. And she knew so much that every negative point would be, absolutely, they should go down. And so there was a real bias there on her part that her theory of how to present it, we adopted some of that for the focus group. And I was pretty confident it wasn't gonna work. And the jury did, the focus group panel didn't like it. You still learn from it. But really forcing yourself to do the focus group, whether you do it or not, but now you got something on the calendar that you have to prepare for. 50% of the value for me of a focus group is just getting ready for it and thinking it through, and then of course doing it. And then, you know, on top of that, whatever you learn from it is great. But that's would be my best recommendation for how to do this, because you can practice. You know, it's like preseason for a professional sports team. You practice, and if you lose, it doesn't matter. It's a good way to practice some of these skills of what we'll talk about here in a minute. So this visual for me really is just a reminder constantly to myself or the people that I'm working with, what's the point? Yeah, there's 15 things, but I don't, and maybe my value is I'm the dumbest one in the group. So if I don't get it, somebody needs to break it down for me, and so I can turn around and make sense of it for somebody else. So the point, right? Another analogy maybe that I'd share with folks and remind myself of, I think we all know what monopoly is. So we have to imagine what it's like for somebody who doesn't know what monopoly is, but we want to play Monopoly. Well, Monopoly has rules, there's strategies, there's points to it. And if you told your group of friends, hey, let's play Monopoly, and they've never played before, you need to explain to them what it is. And not, you know, read the manual, because nobody wants to read the manual. There's a lot of stuff in there. How do you break it down? How do you teach, you know, one thing after the next so that your group of friends aren't so confused about how to play Monopoly? Well, if we're thinking about not our friends who've never played Monopoly before, but a group of jurors, whether they want to be there to play Monopoly or not, they're there. I think my experience, a lot of people try to get out of jury duty somehow, but it seems like most of the time when they're there, they actually take it very seriously. And so how do we teach them how to play Monopoly? Or in other words, not all this stuff, not this whole bag of stuff that I know about my case, but how do I teach them what I think they need to know on behalf of my client about the case? Another analogy, and this is probably the one thing that gave me the most confidence. Desperation caused it, but the confidence to do it, I started thinking about 60 Minutes. And I'm sure a lot of us have watched over the years, I believe it's still on TV, but I know I've watched it when I was younger. 60 Minutes can put an investigative story together with a point that even if you didn't really have a feeling about the issue that they're talking about, by the end of the 10-minute segment, you probably had a fairly strong opinion about it. And so I think they're masters of it. I'm sure people have studied, scientifically or socially how what 60 Minutes does in their broadcast segments. But that gave me the confidence that, you know what, I don't have an hour, I've got 10 minutes in that concept. And how do you put together what you have to say in 10 minutes? Of course, our trials are longer than that, but some of those stories somebody would be happy to talk for 3 days about, the issues involved in that. So, but they do it in 10 minutes, and I think they do it effectively. So that's just something that I offer to you in terms of, I have one foot over the line, but I'm not sure about going all in. 60 Minutes gave me some buoyancy. So this is what you already all know as trial lawyers anyway, but I violated more than I'd like to. Really, what do I need to prove? Well, of course I need to prove as a car accident case, I have to do this, I have to do that. But even then, even if it's a case that you handle all the time, imagine now you're in front of the jury at the end of the trial. What's your special verdict form? What are you asking the jury to do? What's their homework assignment as a jury? And so many times, it seems like the special verdict form is like the last thing I get to. And I've tried to reverse that. So early on in the case, this is it. I mean, this is the play. Then of course the jury instructions, this I feel like a law school professor talking about how to try a trial. You need to know, start with the end in mind. But it's really true, and I think in the busyness of our practices, it's easy to delay that part of, what am I going to do with this case? So I remind myself, I remind those in my office, okay, we think we know this case. We think we've handled this type of case, so many other times. If that's true, even an airplane, jet pilot goes through a checklist before they ever even start the jet. So it's kind of like that is before we start off on our journey, let's make sure we've done what we need to know about flying this jet, or the special verdict form and the jury instructions. And not all of the instructions, remember, the whole idea of this is being selective. So in this process, I'm not just talking about, put your list of jury instructions together or so forth. What are the key things in those jury instructions that you want to emphasize for the jury? And I think that's something you just keep reminding yourself. I mean, I don't know how many times I've read jury instructions, and the 15th case later, I realized there's a word in there that I didn't even really appreciate that it was in part of the jury instruction that actually makes a big difference. So that's my free tip for today. Do what you already know, do what you probably are already doing, but appreciate the opportunity that it creates. And then of course, now that you know the framework of what you have to prove, how am I going to prove it? And so this is, again, it's a visual, but I think one of the things that Joe Fried pushes really hard is you may have 20 documents, 20 pieces of evidence to support this point that you want to make. He would argue, and I've tried very hard to follow this, 20 is too many for most cases. Maybe 20 is exactly what you need in other cases, but I am a firm believer, without much justification for it other than it seems to make sense to me, in that rule of 3. You tell me 3 new things, I can probably remember 3 new things. You tell me 5 new things and I'm going to go about the business of my day, I probably will remember all 5, but I might struggle. So the idea is, if you have 20 witnesses, or if you have 20 pieces of evidence that prove a point, narrow it down to 3. And that's probably the scary part.
Yeah.
And it's kind of like a carpenter. If you measure, design and measure right, you don't have to cut as many times. And so if you put a lot of thought into what you're doing, which of those 20 witnesses are my best ones for this point? Which of the 20 documents are the key ones for making this point? I think that jurors, as much as they want to pay attention to everything, obviously there's a few exceptions, wake up, what do we do about that juror in the back? But odds are that juror in the back probably isn't going to be the foreperson, which I think makes a difference. But what are the three things? So if it's a witness, any witness, what are the three things that I want the jury to remember factually? The impression of them, are they believable? Are they likable? Whatever those other issues are, those are impressions and things that you want the jury to take away too. But in terms of the key pieces of evidence for your case, I've tried to work really hard. What are the three things? Or, team trying to help me get ready for this. Yep, don't put 30 things up on the whiteboard for me. What are the three things up there that really hone in on the point that we're trying to make? And if there's some danger, yeah, they prove this point, but this piece of evidence also creates some opportunities for my opponent. Unless I'm going to be scolded by the jury by not presenting that piece of evidence. Maybe I'll deal with that concept later in the case, but I'd rather have a piece of evidence that is solid on that point and doesn't create other risk. Easier said than done.
Can I ask a trial technique question too?
Yeah.
So if you have a witness up and you're really just shooting for a 15 to 20 minute direct examination and really just trying to pound home 3 points, right? Do you do anything visually to help the jury sort of embed those 3 points into their brain when they hear this testimony?
I try to. It starts with, and I'll talk about this in just a minute.
Oh, I'm sorry.
No, don't be sorry.
Yeah.
So I'm gonna finish this slide because it's a very impactful ending to this slide. I just don't want to waste it.
Right.
So if you have a fourth or fifth or sixth point, you got to figure out, is that point more important than number 2? But really try to focus it down as you're getting ready for trial. This discipline, and I want to be really careful. I'm not telling you what to do. I mean, you're all really talented, experienced trial lawyers. So really all I'm sharing with you is what seems to have worked for me for the most part. In the office, let's focus on what are the key things. And if you absolutely, but we've got 5, 6, and 7 that are just blow it out of the water too, which, blow it out of the water, how often does that actually happen? But odds are you blow it out of the water if that evidence exists is probably number 1 or 2. How do you make it easy for the jury to get these points and to remember them? I think it's the power of 3 or less. Again, I don't try complex, commercial litigation or employment law cases or anything like that. So I don't mean to suggest that I know everything that you do in your practice. And this might be a totally different perspective for a lawyer defending a case that I'm bringing. Again, I do think you want to be clear for the jury, but I know that there are some defenses that the more they muddle it up, keep it muddled up, the more confusing it is for the jury. That might be a successful tactic for them too. It's not for the plaintiff, as far as I'm concerned, because if you don't make it crystal clear for the jury of what's important, then they make it up on their own. And even then, they might take your 3 compelling points and interpret it the way that they want to anyway. But so the way we do it is in the jury selection process, I try to show the jury that I actually care about their time. Most of them probably didn't want to be there. Most of them have things going on outside of this case. They've got real life issues. You've heard about all those already at this point, where the judge and the opposing counsel has covered, the fact that their inventory and their business is due this week, and if they can't do it, or my kid is sick, or my daughter's going to college, whatever the issue is, I truly want them to know that my goal in this case is not to waste anybody's time. So in terms of this process, this speedy trial process, I think there's only so much I can do properly over here in terms of trying to indoctrinate or anything else. But I try to be efficient with my time, respectful of their answers, and indicate to them that I'm not going to be somebody that's going to be wasting their time in this trial. Because I do think, I've never served on a jury, but I do think if I was serving on a jury, my first question would be, who's responsible for me having to be here? You know, which side is not being reasonable? So I try to come across as the side that isn't why they're here, but here we are, and this is important. In the opening statement, this is a chance where I do have a chance to emphasize, the efficiency of it. I try to, here's what we're going to be showing them. There's no secrets. But in terms of what's going to happen, here are the witnesses. But to your question, I think this works, maybe not all the time, but I like the old easel, write on an easel. And if you have your solid 3 points, it could be 2 points, it might be 4, but it probably should be 3, that you want the jury to remember all the way through the trial. I've written them down, and preferably a 1 or 2 word expression for each of those points. I think that's interesting enough for the jury that now you're actually doing something. And then I can go back to that throughout the trial with the witnesses, and then in closing. That might be all I do on the paper with the marker, but it's really meant to create clarity about what to expect, the points that we're going to be trying to make in the case, and then hopefully reinforcing my credibility that we've done that throughout this trial, or this second point is really important for this witness. It may be worth bringing the handwritten easel back out.
Can I ask you one more
Yeah.
opening statement question? I know we've probably all wrestled with this. How long is too long? How long is too long? Is there a time where it's too short, whatever? Using this method, do you have a rule of thumb for yourself as to how much time you will spend on opening?
I shoot for 20 minutes. I would say 15, but and I know I would probably be wrong. Maybe next year I could come back and say, got it down to 15.
Yeah.
But I think you can make your point, because frankly, I go to church every Sunday and I listen to the pastor give his sermon, and it's a good opportunity for me to be a critical listener of, and when it's too long, right? And most speakers aren't going to be compelling enough to make you want to continue sitting there to listen to more. And I think that's like probably most of you are feeling right now. The good news is there's only 10 more minutes of this segment. But you have a sense for when it's gone too long. And I try to come way short of that. Here's why we're here, here's what we're going to show, these are the main points, these are the witnesses, here's why. In the end, there's an ask. My job is to prove to you that my client's entitled to that. And I wish it was that short. There's the commercial, I forget which company it's for, but the guy stands up in front of the group and he says, "Good morning," and then his next comment is, "But I digress." That's pretty short. But if I could hit 15 minutes and feel really comfortable that you're going to remember what it is I didn't promise you, but I'm asking you to test me. Did I prove these things? And I think you can probably do it in 15 or 20 minutes. I know there's lawyers in this room that could go for an hour or 2 hours and keep the attention of the jury. I can't. And I don't have that kind of attention when I'm listening to somebody else. So I believe that point is really important. And then with the witnesses, most of the witnesses that I called, I got through them in 20 minutes or so, each one of them. Now, in terms of Speedy, the opposing counsel, or if you have 2 opposing counsel, they can undo your Speedy by not being speedy. And usually in my experience, the lawyer on the other side who's not being speedy wears out their welcome with the jury, probably within a couple of witnesses, particularly when it's now, how many children do you have? All the things that nobody cares about. And there are questions that are asked because I think they're afraid just to get to the point. Now, if children are important to the case, it probably makes a difference, but just, I don't really care who you are, other than why are you here, and are you worth listening to, and what you know that is important to these three things in the case, or at least one of those three things. So I think the more experienced opposing counsel, the ones who really understand the Achilles heel, or the efficiency of time, or developing trust with the jury, aren't going to read from their outline and bore the jury. But if the second witness comes up and I've done the same thing, boom, 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 no BS, no fluff, just this is what we're here to talk about. And if the defense lawyer does the same thing, I've actually had, maybe it wasn't the second witness, but it might have been the third, where somebody on the jury actually groaned when out came the outline. And so the idea is, what are they even listening to at that point? And maybe that's part of the defense strategy in the case, I don't know. But if you're trying to teach people how to play Monopoly, I don't think that's a very good way to do it. Teaching people how to play Monopoly isn't taking the instructions out and reading it word for word to your friends. So that's kind of the witnesses. And in the cross-examination, some of the expert witnesses I see in these cases, I don't want to call it friendship, but hey, doctor, good to see you again. How's it going? And not to give them credibility for that, but it's, they've been around. If the jury sees me as somebody that's been around, so is that man or woman on the witness stand. But a 5-minute cross-examination, even of an expert, in some cases you might really have to go into all of the details, but for me, it's what are the key points that I want to get out of that witness. Some of the cross-examinations, of course, are longer than that, but I shoot for what could I do in 5 or 10 minutes with this witness that's going to make a difference. And then the closing argument, I always, in those 3 cases, the judge will always ask, how long do you think it will be? Let's budget our time. I'll say 30 minutes, and it'll end up being 40 minutes, like that, but I'm not too far off. I use a PowerPoint in my closing. I try to show that, here's what we have to prove in this case. The judge is going to show you the special verdict form. These are the questions you have to answer. This is your job. And here's how to answer them and why. And then picking out those 3 or 4 key jury instructions that are important for them to follow in doing so. I think that if I have had any success with that, it has been because I've been able to, they may not like me, I hope they do, but I think they at least respect that I'm being straight with them. All you have to do is one screw up and whatever credibility you've built could be wiped out real fast. But it was kind of fun. In some of those cases, I kind of felt like the jury was interested in what I was going to do next with the jury. That had not been my experience as a trial lawyer until I went all in on this. So that's basically it on this. Now, to be candid, like Joe Freed would be, I lost a trial in November. Fortunately, it wasn't a nursing home case. I like to win those, and I like to win them all, but this was a negligent security case against a bar. And I tried to do the Speedy trial. I think I was efficient with the jury, but it had a lot of surveillance video evidence. And the court's system for displaying that did not work well the first day. So there were just a lot of trying to walk through, I'm just trying to show, folks, this is really interesting. I want the witness to be able to explain it. And we're having to really jerry-rig a lot of different ways to do it the first day of trial. But all of my liability witnesses, the depositions went really well. Depositions are a big part of being able to do this at trial. I had 4 lay witnesses in that case. They were all employees of the bar on the night that my guy got killed. And their testimony was great. I mean, the jury said yes to negligence. They just didn't say yes to causation, which I have a hearing this afternoon to enjoy that conversation with the judge on a new trial motion. But and the defense lawyer was very good at just pouring molasses all over everything. I think it was not a matter of ineptitude, it was a matter of he was skillful at it. And so as fast as I want to run in the case, you are tied a little bit to your adversary, your opposing counsel, in terms of, how much can we get done in a day's time with the jury. And of course, the breaks in between, witnesses and so forth, the jury doesn't know why they have no idea why it took so long from the time we were in the courtroom last until we were in the courtroom again. And I never did figure out how to. You wish you could stand up and tell them it's not my fault that you had to wait so long, but you can't. So anyway, there's a couple minutes left. I know you had questions about this. This was really, again, I'm not here to tell you what to do by any means, but it's something that I've been working on very seriously. I had a trial that was scheduled for April, but the judge broke her ankle in a skiing trip, so that's going to be in November. I was looking forward to doing this again. The nice thing about having the 3 cases together is it gave me a really good chance to try to refine from one case to the next, some of these techniques to speed things up. And of course, if you think it works the last time, it gives you confidence to do it again. Yes?
So I understand paring down your witnesses. You talked about paring down documents to 3. Is that by only introducing a limited number of documents, or by only discussing them with witnesses in the closing?
And the goal is, because you may end up having more documents to deal with depending on what your adversary does, to rebut or to address, but the pile of exhibits end up being huge, because in my cases, it's somebody who's 90 years old who got dropped from a lift or something, and the medical records are like that, and I just want to introduce this much because I think that's the only thing that's relevant to it, but the other side wants to have all of them. So it's to answer your question, it's what we try to focus on for the jury. Not that there aren't more exhibits, but if what I show you and I sit down and you can remember hopefully at least 2 out of those 3 points, and in some cases it might only be 1 point. I don't know what that case is, but for me 3 seems to work. And you might test your 3 in a focus group and find out that wasn't the right 3, or maybe we only need 2. So I don't mean to make it sound like it's a steadfast, 10 commandments thing, but that's the goal. Hi.
Could you elaborate a bit on how you pared down your presentation of expert witnesses and how you, in particular, how you dealt with and condensed the foundation?
Yeah. So some of it seems like experts are a common thing now in my motions in limine. They're not qualified, or they can't talk about this, that, or the other thing. So we've gotten a heads up, already about what they're going to be allowed to testify about and so forth, or what the defense might be doing with them when they do their cross. But what I did is the script, basically, it's almost as much of a script that you're going to get from Joe Freed on his concepts, but it is I call Dr. Smith. Judge has the doctor come up, swear, and then doctor, why are you here? Now, we've talked about this a little bit before the trial actually started, so they're not surprised. But I'm here to testify about this. What qualifies you? I was nervous about that question because the witness doesn't qualify themselves. But what qualifies you to be able to talk about these things with the jury? Well, this, and this. Introduce the CV, offer the CV, even if it's, if you offer the CV, no objection, the court accepts the CV, and then you offer the witness as an expert witness pursuant to Rule 7 or whatever, and the judge, any objection, no, or none other than, what's already been in the record. They admit your expert as an expert. And I've done all of that in probably less than 5 minutes. And how many cases have I tried where you spend the first 30 minutes talking about your chiropractor's, history of education and all this stuff, and nobody cares, in my opinion. But they do care about why this person is here and what they're doing, and then you have to hit certain points, okay, and you've reached opinions in this case. I have. Tell me what, your hopefully 3 opinions are, there might be more. Okay, then let's go through and talk about those. Why did you reach this conclusion on your first opinion, second opinion? And it's probably about a 20-minute, maybe a 30-minute, depending on how much evidence you have to show, direct examination. And I think the jury gets it. They understand why that witness is there. Here's the couple of things that they had to say that I hope the jury will remember. Otherwise, last thing I'll say, and if I'm missing anybody's question, I'm sorry, but if you've ever sat in the back of the courtroom while you're waiting for your case to come up for a motion or something like that, and you're listening to some lawyer talking about his client's case, that it's just the most important thing and they're really into it and all that, and you could care less, you might appreciate their technique, or I'm not sure if I would have said that, or maybe you should sit down now because the judge isn't listening, but in terms of what they're actually arguing about, unless it's your kind of a case where you've got a fence line issue yourself with your neighbor, you're probably not really interested in what's being said. And I think the jury's the same way. I mean, it amazes me how much the judges pay attention to, because frankly, I think I would fall asleep. That's my attention span, but the judges I've been in front of probably for the last 5 years, I've been, congratulations to those involved in helping the governors to appoint judges, but I think it's been a really good group. I've been really impressed with them. And a lot of people who were defense lawyers before they became judges. So anyway, I hope this, yes, sir.
So Jeff, going back to your guy who went out the 3rd floor window, do you happen to remember what your 3 points were that you ended up focusing on in that case?
Yeah, so there's an algorithm, probably for all of us, but definitely for nursing homes. They have to assess, they have to have a care plan, game plan to deal with the residents' needs, and they have to implement that care plan. And if it's not working, so I've turned 4 into try to 3, if the care plan isn't working, you have to evaluate why and revise it. Well, he went out a window on the 3rd floor a couple of days before he went out. No, he didn't go out the window. A couple of days before, he was able to open a window, and these are windows that you're not supposed to be able to open. And then he was able to open the window once again, and then he ended up going out the window. He had, so one of the things we did in that case is, and I'm going over, I'm sorry, but we did not ask for future pain and suffering. We only asked for past pain and suffering and past medical bills, nothing for future. And that was a calculation we made because after he was hospitalized for this, he went to an assisted living facility, 1st floor, but he was able to get out the window. And so I didn't want the jury to, this is just somebody, there's no way you can contain him. It doesn't matter what kind of cage you have, the dog's gonna get out. So by cutting off our damages into the future, which was kind of murky anyway, I was able to keep out the subsequent event at the assisted living facility where he went out. So it was the 3 things that we really focused on are what did this nursing home have to do to assess his condition? In other words, what do they know and so forth? What was the game plan for dealing with him? And did it work? And they knew it didn't work because he was able to open the window before. So anyway, it probably doesn't really fully answer your question. I apologize. But do we have time for one more? Or I don't want to read any, or 2 more? Okay, 2 more questions. Sure. If we can start back there.
How do you get the defense to agree to this? Do you have a document that you prepare and execute, or what's your procedure?
don't think there's a lot of agreement. I mean, you have your stipulations, like the medical bills and things like that. Am I really gonna have to call, the billing people from 6 different providers to get the bills in? Judges are a good advocate for me if there's some dispute on that. And so I haven't had to produce, a day's worth of people just to establish foundation for the medical bills. So, I mean, there are stipulations and things like that that you do on every trial if you can. But the way I do it is you hopefully know what you're doing in mind to do it. And I guess one thing I can add to that is this approach with the expert witness, introducing them. Here's why they're important. Here's why you should listen to them in 5 minutes. One of the attorneys in the second trial said, I really like that. I'm going to do that. So, if it works or they think it's working, you'll start to see them emulating some of what you're doing. If it's not working, then you probably won't do it again the same way. But so there's really no, I don't talk to them and say, I'm going to do a speedy trial. Because my experience is anytime I say I want something, then that's exactly what they don't want. But I don't need their cooperation for it. I think we had one more question right there.
Condensing liability and causation, I think, is something we can understand logically how to do that. But how do you condense damages and teaching the jury how they should calculate money for things that are non-economic?
So 2 of the cases I had large medical bills. And not that that's necessarily a multiplier, a factor for multiplication, but if you have $250,000 or $500,000 in medical bills, that gives you a pretty good anchor to build from in terms of the jury. And it's not like a Ford pickup truck where you can look exactly the model, make, color, body damage, and find out a pretty good idea what it's worth. We've been seeing some serious verdicts on for the plaintiff. There's still plenty of defense verdicts, but juries, if they seem motivated by the evidence that has been presented to them, seem to be going with bigger numbers. When I do focus groups, I like to have a conservative group of people. My thought is if I can convince a conservative-minded person of the importance of this, for me, it's easier for them to think of big numbers than it is. Hopefully this isn't a derogatory term, but I may convince a liberal hippie, if there are such things anymore, that I should win, but their value of money may not be the same as a more conservative-minded person. Is there science to back that up? No. Well, maybe, I don't know. And but my focus groups have at least validated that concept. So I like conservative jurors. Thank you very much. I hope there's some value in all of this. Nate and I, obviously, if you have questions, please follow up. I'm sorry I can't stick around for the rest of the presentation this morning. I'm very grateful that you had me today as a guest. I gotta go get ready to convince the judge that she should have ruled a different way and see if I get to try that case all over again. But thank you very much. I appreciate it.